My lord, this is in company appeal. It has been filed, my lord, challenging the award, whereby the driver, he was driving the truck, my lord, it was overturned and he died. There is a pleading. I would read, my lord, para 1 of their application. Under section 166, my lord. यह की घटना दिनांक, may I read, my lord?
एक सेकंड मेरे को जी, यह की घटना दिनांक
15/7/2000 को मृतक विजय सिंह चालक की हैसियत से ट्रक क्रमांक MP 13B1951 को भोपाल से चलाकर सागर जा रहा था। जैसे ही ट्रक ग्राम चंदोनी के पास पहुंचा कि रास्ता खराब होने के कारण ट्रक पलट गया। मृतक विजय सिंह ट्रक के पलटने के कारण घटनास्थल पर ही मृत्यु हो गई। दिस इज देयर केस, माय लॉर्ड, and the application was filed under section 166. Subsequently, what had happened, my lord, that the claims tribunal has converted it to 163A and award has been passed. In this case, my lord, it can be done, but not when under section 140 of Motor Vehicles Act compensation amount has been received.
जजमेंट लाई है क्या आप?
My lord. Lord, this is 2004 volume 5.
2004
volume 5 SCC 385, my lord. Deepal Girish Bhai Soni and others.
तो जी इसमें क्या कहा?
इसमें तो
ये कहा इन्होंने
जी
कि इसमें तो ये कहा है कि एनी टाइम बिफोर पासिंग ऑफ द फाइनल अवार्ड इट कैन बी कन्वर्टेड फ्रॉम 166 to 163A or vice versa.
Issue was raised, my lord. Issue was different in this case.
that क्यों रिलाय कर रही है? इसका तो रेशियो यही है.
That is also, my lord, one of the principle which has been laid down by the Apex Court. Para 41 to
Para 41.
Para 41 onwards, my lord, I would read para 46. Actually, relevance start from para 41, but the para 46 is the answer of that question, my lord.
Para 46 question.
जी 163A, para 46, my lord. Section 163A, which has an overriding effect, provides for special provisions as to payment of compensation on structure formula basis. Subsection 1 of section 163A contains non-obstant clause in terms whereof the owner of the motor vehicle or authorized insurer is liable to pay in the case of death or permanent disablement due to accident arising out of use of motor vehicle, compensation as indicated in the second schedule to the legal heir or victim as the case may be. Subsection 2 of section 163A is in pari materia with subsection 3 of section 140 of the Act, my lord. My lord,
क्या मतलब हुआ?
This indicates, my lord, that the section 163A and section 140 are the same, my lord, because 140 is also under no fault liability, 163A is also under no fault liability, and the two sets are provided by the statute, my lord. Number one is 140 and 166, my lord, which is available to all section of the society, whereas 163A would be available on to those, my lord, claimants whose the deceased income was less than 40,000. In this case, that is not the dispute, my lord. Admittedly, the tribunal has taken the income of the deceased less than 40,000. But here question is, my lord, that they have accepted the award under section 140. So after
an interim award, आप तो इतना बता दीजिए कि interim award के बाद में conversion नहीं हो सकता है. This is the only legal issue.
Yes, my lord.
उतना judgment बता दीजिए.
Yes.
That if one accepts interim award under section 140, then he is precluded from converting his application from 166 to 163A.
My lord. My lord, para 51.
Para 51, yes.
Para 51, 52. Para 50, my lord. I'll read.
Ji, please.
Apart from the fact that compensation is to be paid by applying multiplier method under the second schedule, other relevant factors, namely reduction of 1/3 in consideration of expenses which the victim would have incurred towards maintaining himself. General damages in case of death, as also in the case of injuries and disabilities, as also disability non-fatal accidents. A notional income for compensation to those who had no income prior to the accident are provided for, are required to be considered, which is also a clear pointer to the fact that thereby Parliament intended to provide for a final amount of compensation and not an interim one. The scheme envisaged under section 163A, in our opinion, leaves no manner of doubt that by reason thereof the rights and obligation of parties are to be determined finally. The amount of compensation payable under the aforementioned provision is not to be altered or varied in any other proceedings. It does not contain any provision providing for set-off against a higher compensation, unlike section 140. In terms of the said provision, a distinct and specified class of citizens, namely persons whose income per annum is rupees 40,000 or less, is covered thereunder, whereas section 140 and 166 cater to all sections of society. It may be true that section 163B provides for an option to a claimant to either go for a claim under section 140 or section 163A of the Act.
Para 53 पढ़िएगा.
जी.
शायद इससे कुछ समझ में आए.
Although the act is beneficial one and thus deserves liberal construction with a view to implementing the legislative intent, but it is tried that where such beneficial legislation has a scheme for its own and there is no vagueness or doubt therein, the court would not travel beyond the same and extend the scope of statute on pretext of extending the statutory benefit to those who are not covered thereby.
देखिए ये 58 पैराग्राफ पढ़िएगा, शायद इसमें भी कुछ मतलब की चीज है.
Lord, 58 Kandala judgment is, my lord, that
Kodala, not Kandala.
Kondala. Kondala. The contention of the claimant is that right to get compensation is in addition to no fault liability was thus rightly.
तो ये सेट ऑफ हो जाएगा.
सेट ऑफ नहीं परमिटेड ना सर, यही तो बात बोली है इसमें.
ठीक है,
पैरा 52 में.
चलिए इसको
पैरा 52 में एंड पैरा 51 में.
सैटरडे संडे को लिखाते हैं इसको.
जी. That is
the only issue raised in this case is that originally a claim application was filed under section 166 of the Motor Vehicle Act. Full stop. Thereafter, claimants received interim compensation as is provided under section 140 of the Motor Vehicle Act. Full stop. Thereafter, tribunal converted the claim to one under section 163-A. Full stop. Learned counsel for the appellant, insurance company submits that once interim compensation was accepted under section 140 of the Motor Vehicle Act, then claimants were precluded from claiming any further amount because, as per the judgment of Supreme Court in case of Deepal, Girish Bhai, Soni and others, versus United India Insurance Company Limited, Baroda, comma 2004 bracket में bracket close 5 SCC 385. Both the proceedings under section 140 and 163A are para materia to each other. Bracket में लिखिएगा para 46, and therefore there being no provision for adjustment of the amount already paid under section 140, comma no adjustment could have been allowed under section 163A. Next paragraph. बताइए इनकी 140 की एप्लीकेशन कहाँ है?
सर इम्प्यून ऑर्डर में है।
इम्प्यून ऑर्डर में क्या लिखा है, पढ़िए। 140 ट्राइब्यूनल ने अपने आप दिया कि इनकी एप्लीकेशन पर दिया? ये भी एक इशू आएगा
जी। पैरा 12 माय लॉर्ड,
हाँ
सब नेक्स्ट पैरा 12 का सब पैरा, यद्यपि इस प्रकरण में माय लॉर्ड हैज गॉट,
हाँ
यद्यपि इस प्रकरण में आवेदकगण के योग्य अधिवक्ता ने तर्क के दौरान उपस्थिति इंगित किए जाने पर अपने अधिनियम की धारा 166 के आवेदन को संशोधित कर अधिनियम की धारा 163A के अंतर्गत परिवर्तित करने का प्रयास नहीं किया है, बल्कि उनके द्वारा अधिनियम की धारा 140 के अंतर्गत अंतरिम प्रकरण की राशि प्राप्त कर ली है।
जी। ठीक तो लिख रहे हैं ये, चलिए।
Sikkim High Court. I was just searching for a judgment, my lord. So the one divisional bench judgment from the Sikkim High Court seems to be saying that once you have chosen to go in the way of 140, then 163A would not. I'll just
chosen, इसीलिए तो मैंने पूछा where is the application?
I'll just submit this judgment.
हाँ हाँ दे दीजिए।
It seems to be of the April 2022 divisional bench judgment.